You've seen it 1,000 times in movies, right? The interrogation room, the pressure, and then finally, the suspect cracks and confesses. It always feels like the case is officially solved. But what if I told you that in real life, getting that confession is really just the beginning? Today, we're going to dig into the fascinating legal rules that decide if a confession is even allowed to be part of the story. So yeah, a suspect confesses. You'd think, great, pack it up, we're done here. But the law is way more interested in how that confession happened. It asks this really fundamental question. Was the person actually free to choose when they spoke? Because if there's any doubt about that, well, that case-closed confession might just get thrown out completely. And this all boils down to one central idea. It's called the voluntariness test. Honestly, this is the standard that everything else is measured against. It's all about making sure a person's free will wasn't compromised.
Okay, and here is a super important distinction the law makes. When you and I hear the word voluntary, we probably think someone just, volunteered information. But in a legal sense, it's much more precise. It means the person made a real, free choice to either speak or stay silent without being pushed or manipulated.
So how in the world do courts figure this out? Well, they use this 5-point test, which is broken into 2 main parts. First, you've got 2 strict, absolute rules. If you fail one of those, the confession is out, no questions asked. Then, after that, there are 3 judicial discretions, which are kind of like safety nets for the judge to ensure everything is fair. Let's start with those strict rules. All right, first up, the non-negotiables. You can think of these as bright red lines. If the police cross either of these lines to get a confession, it doesn't matter how convincing it sounds, it's not coming into court, period. The first one is called the inducement rule. It's very specific. It asks, did someone in authority, like a police officer, make a threat or a promise? It's something like, just confess and I'll make sure you get a lighter sentence. That's an inducement. The second rule, basal involuntariness, is a bit broader. It looks at the whole atmosphere. Was there so much duress, intimidation, or just nonstop pressure that it basically just broke the person's will? This quote from Justice Dixon just nails it. The key word here is overborne. It doesn't matter how a person's will was overborne. If they're speaking because their will to resist has been completely crushed, then what they say can't be used. The choice wasn't really theirs anymore. But even if a confession makes it past those 2 strict rules, the court's job isn't done. The law gives judges 3 more tools. These are the discretions, and you can think of them as safety valves, designed to catch anything that might still be fundamentally unfair. For instance, a judge can throw out a confession if it was obtained improperly. Maybe the police used a trick or a lie. They can also toss it if, looking at everything, it would just be plain unfair to use it against the person. And finally, they do a balancing act. If hearing the statement would prejudice the jury against the accused more than it actually helps prove a fact, the judge can decide to exclude it. And this quote from Justice Brennan adds another really important layer. It shows that these rules aren't just about policing the police. The real ultimate question is about the effect of the police conduct on the suspect's mind. It always comes back to that one question. Was this a free choice or was their will overborne?
And what's really crucial here is that the court isn't judging this against some imaginary average person. No, they have to look at the specific individual sitting in front of them, their age, their background, their psychological state at the time, and all the circumstances around the confession. The whole test is subjective. It's tailored to that one person in that one room.
Now, you might be thinking this all sounds like it's for those big I did it confessions. But what about other stuff? What if someone is under all this pressure and they just lie? They deny everything, but they do it with a lie. Are those statements protected too? Oh, absolutely. The law protects any statement that is inculpatory, which is just a legal way of saying any statement that helps prove guilt. It doesn't have to be a full admission at all. It could be something as simple as admitting a key fact, like, yeah, I was at the location that night. If that little piece of information was coerced, it's out.
And this is where it gets really interesting. This quote explains why even a coerced denial can be kept out of court. Think about it. A prosecutor can take that denial, prove it was a lie, and then turn to the jury and say, see, they're lying to us, and people only lie when they have something to hide. So as Chief Justice Warren says, that lie becomes incriminating. And if it wasn't given voluntarily, it can't be used. So when you take a step back and look at the whole system, you see what it's all about. This entire legal framework isn't just about abstract rights. It's about something much more practical: the search for truth. The law understands that a statement made under extreme pressure is just
unreliable. The whole point is to make sure any confession a jury hears is actually trustworthy, that it came from a free choice, not from pressure.
And that really leaves us with this huge, difficult question. How do you balance the real need for police to investigate and solve crimes with the fundamental duty to protect a person's free will? Finding that perfect balance, well, that's one of the toughest tightropes the justice system has to walk.